in that area.
Phil Twyford.
Thank you, Mr. Chair. Also, as a non-lawyer, I must say I found this debate very interesting, and like Chris Hipkins, I've been following the public debate as this bill has progressed, and observed the negotiations with a great deal of interest. And I really appreciated the Honourable Rick Barker's comments about the sort of provenance of this bill and the sort of impassioned plea that Rick Barker made about the need to modernise the administration of justice. I just wanted to confine my comments to Labor's SOP and invite the Minister in the time remaining to get up and respond to some of the clauses that are proposed in Labor's SOP. And for the benefit of people at home, let me just speak briefly about what is contained in this, the amendment that Labor's put on the table in the name of Charles Chevelle. Included there is a clause 25A, which inserts a procedure modelled on clauses in the Summary Proceedings Act, which would provide for an on-the-spot summons procedure to apply in certain limited circumstances. Clause 26 inserts a new clause which clarifies the procedure to be followed following an evidential breath test. Clause 35 ensures that the defendant is not required to plead unless the defendant has had at least 21 days to consider the material obtained under disclosure from the Crown. There are a number of minor things here, but worth probably just mentioning. Clauses 58 to 63 substitute the word undertaking for the word indication, which is, I think, designed to ensure consistency with other statutes. Clause 105 sets out to modernise the law as to when the court may be addressed on evidential issues. And then I think probably the most substantial part of the supplementary order paper is additions to clause 128, which have the aim of confining further the circumstances under which trial and sentencing can continue in the absence of a defendant. And this is to ensure that the court may not proceed in the absence of the defendant when a reasonable excuse for that absence has been given. The court is asked to consider a number of things, a number of factors when making a decision about whether to proceed in the absence of a defendant. And these things would include any information available to the court about the reasons for the defendant's absence, any issues that the defendant has indicated that are in dispute, and the extent to which the evidence is critical to an evaluation of those issues, the likely length of an adjournment. And in spite of the fact that the court can consider and decide whether to proceed in the absence of a defendant, the court must not proceed under these provisions unless it's satisfied. If it's satisfied that it would be contrary to the interests of justice to do so. So, would particularly appreciate a response from the Minister on the additions to clause 128. The final two elements, clause 176A, will prevent the prosecution from offering new evidence or correcting deficiencies where earlier offering or correction was reasonably foreseeable. And clauses 361 subclause 1, 361 subclause 2 restrict the circumstances in which a costs order against the defendant or the defendant's counsel may be made to cases where a failure is exceptional and intentional and done without reasonable excuse. So those are the elements in Charles Chevelle's supplementary order paper, and in the time remaining we would really appreciate a response from the Minister.
Carol Beaumont.